consent order. And he asks how that fits with the orders in Section 4, Section 6, Section 6A, right? That's your question. There are different concepts, basically. Section 4, Section 6, Section 6A are the available orders in law, like what forms of financial provision you are able to get as your spouse. A consent order is the type of order when you settle the case. Okay, the different thing, because after you have a trial and then the court would give a judgment and a final order on how things should be dealt with on the financial side, a consent order is an order after you reach a settlement instead of after a trial. It's a form of order. It's a concept in civil procedure, basically. Okay? It does not indicate a form of ancillary relief you get. Okay? It suggests that you have a settlement or you have agreement. It's not decided by the judge, but agreed between the parties. That's a consent order. Remind me about this when we talk about FDR in the lecture on the 5th of January. Okay? Or we can talk about this after class today. So this slide is on the background of how we come to LKWNDD. It's also part of the judgment of LKWNDD by the CFA. It's about the history of law development, basically. So many, many years ago, in the 70s in the UK, you have this case called Wachtel and Wachtel. I think that's German. I don't know how to say it properly in English. Wachtel and Wachtel, whatever you like to call it. In that case, it's a judgment by Lord Denning. Lord Denning ruled that under the facts of that particular case, a reasonable starting point for award to a wife would be 1/3. That's what Lord Denning said in that case. And he continued in his judgment and anticipated the possibility of equal division of family assets between husband and wife, which might be appropriate in the future, but not in this specific case. In Wachtel and Wachtel, the appropriate portion is 1/3 awarded to the wife. It doesn't say that there is a presumption of the law that a wife will get 1/3, but for some reason, the following cases all cited 1/3 as a rule of thumb. Okay, so there is some sort of misunderstanding there in case law. So back then, that would have been the law to be applicable in Hong Kong. And then we come to Preston and Preston in the 80s in the UK. It's the judge was Judge Armrod. He ruled that an appropriate approach is to look at the wife's reasonable requirements, and he attempts to ascertain what capital sum she would need to achieve a clean break to live comfortably. So in Preston and Preston, there is this qualification of reasonableness in assessing the needs of the wife. Okay. I use wife and husband because traditionally it's the husband who would maintain the wife, and it's easier to say husband and wife than the payee and payer party. Okay. So in Hong Kong, in the 1990s, there is CNC, which is a big money case back then that reached the level of Court of Appeal. The Court of Appeal in CNC said, relied on the English case of Preston and Preston and stated that the court would first evaluate background noise. In CNC, our Court of Appeal said that it needs to firstly evaluate the financial resources of both parties, and after that, we need to turn to assess the wife's reasonable needs. If there is any surplus after satisfying the wife's reasonable needs, then the wife might qualify for a larger award if she has earned it by contributing financially to the family assets. But when you qualify the needs with reasonableness, the surplus are not necessary for distribution. Okay, so basically, CNC applied Preston. Back then, in the 80s, in the 90s, in the UK you have Preston, in Hong Kong you have CNC. There is a cap on the awards to the wife, being that it has to be reasonable. Okay, reasonable basically means just enough to satisfy your needs. And this is very unfair. And in CNC, it says if you want to go beyond reasonableness, you have to show that you have contributed to the family financially. So if you have a stay-home wife, there's no way you can go more than reasonable. Okay? And even if you can show that you have financial contribution, it's not necessary that you can get more. So the likely result is still reasonable needs for the wife, with the rest to the husband, which is very unfair. So in 2000, there comes the case of White and White before the House of Lords in the UK. It was a big money case. It involved a family which engaged in farming business, which was quite successful. Over a long marriage of 33 years. They have 3 children. One of the children died tragically, and the other 2 children were adults at the time of the divorce. The Preston approach from the 82 was applied at the first instance, and it was held that the wife would require a farmhouse type of home with stabling and land for her horses that represents her reasonable needs. But on the other hand, the husband would have an amount which exceeds his reasonable requirements in terms of a home and income, and the husband was allowed to continue to farm. The result of that ruling is that the wife received only slightly over 1/5 of the total matrimonial assets in that case. That's that's prior to 2000. But when you have 1/5, it's even less than the 1/3 in Watchtoe and Watchtoe in the 70s. So that was highly unfair, and it went on appeal. On appeal at the CA level, the award to the wife was increased to approximately 2/5 of the matrimonial assets, having regard to the parties' contributions to the farming business. And with that decision, both parties appealed to the House of Lords. The wife asked for equal division, and the husband asked for restoration of the first instance order. That's 1/5 to the wife. So in the House of Lords judgment, eventually, I think, as a matter of the financial result, the House of Lords upheld the CA decision of giving 2/5. But then, in this landmark case of White and White, the House of Lords gave a very detailed analysis on equality, financial resources, and financial needs. And it is in this case that the House of Lords coined the term of yardstick of equality. Okay. So the law in the UK changed in 2000. And then 10 years later, there is the LKWNDD, which came before our CFA. And then we changed the law according to White and White. What happened in LKW was that the parties were married in 1996, and they issued a joint divorce petition in 2003, post White and White. The wife had worked periodically during the marriage, and the husband is the sole proprietor of a company, and he's also a director and shareholder of 2 other companies in Hong Kong. At trial, it was held that the husband had a total asset of 4.65 million. So it was not a big money case, and the wife was awarded in the sum of 1/3 of the matrimonial assets, being 1.55 million. That decision, that award, was overturned at the appeal because the trial judge applied CNC, the reasonableness test, which was based on Preston and Preston. And Preston has been overruled by the House of Lords in White of White. Okay. And when LKW and DD came to the CFA, the issue was in light of the change in the English law by White and White 2000, whether the Hong Kong case of CNC stands as good law, and if not, whether we should adopt equal sharing, the yardstick of equality from White and White. So basically, our law development looks at the law development in the UK. It was held in LKW and DD by our CFA that CNC should be overruled. The ordinance does not say explicitly that the aim of the court is in exercising its power, but implicitly the objective must be to achieve a fair outcome in the parties' financial arrangement in the dissolution of marriage. Okay? Our law, the legislation doesn't say it explicitly, but this must be the goal, that is to achieve fairness. CNC would lead you to arrive at an unfair result because it constrains contributions to one of financial in nature. Okay? So remember, in CNC, the starting point is reasonableness, and if you want to get more, you will have to see if there is any financial contribution by the wife. So contribution in CNC is limited to financial in nature. But if you look at Section 7, which I read to you once before the break, it requires you to look at the contribution of the parties to the welfare of the family. The welfare, and not just the accumulative wealth. Okay, in terms of contribution. And further, Section 7 requires the court to look at all of the circumstances of a case. So there is no justification for treating the needs of the wife to be limited by reasonableness. And also the concept of fairness evolves from time to time, and it was said in LKW that what is set out in CNC do not reflect fairness between husband and wife in present day anymore. So what should be the law in Hong Kong? Our CFA have considered authorities from Australia, but there are significant differences in our legislation from the Australian legislation. Their case law is based on a completely different, very different statutory framework, and hence does not inform our approach to Section 7. But on the other hand, our Section 7 in MPPO is very similar to Section 25 of the UK Matrimonial Causes Act. Okay. Section 25 of the UK Act is the English equivalent to our Section 7 MPPO. So the result is that we look at White and White. Okay, that's how White and White was basically adopted to be the law of Hong Kong on ancillary relief. The judgment has done an overview of the history and the law development, and I just summarized it for you. Okay. So, given the above background, the CFA has arrived at 4 principles in applying the Section 7 factors. If you have the judgment, the 4 principles are discussed in paragraph 56 to 70. So the first principle is the objective of fairness. Okay. And in a similar vein, the second principle is the rejection of discrimination. There should be no discrimination based on gender or the role that a party plays in the family. That is especially in the old days, the husband makes the money and the wife is a stay-home wife, and after divorce, the husband continues to make money and he's free to marry a second wife, and it's easy to find a second wife for man. Whereas for women, once you become a homemaker, then you lose earning capacity. You might not have earning capacity to begin with in the old days as a woman. And even if you do, then you lose that earning capacity. And it's hard for women to remarry. Okay? And this pattern has changed. So the law should reflect that reality and the modern spirit in our law. So basically with the objective of fairness and rejection of discrimination, it shows that the law discourages and does away with inherent unfairness seen many, many years ago in our society. The third principle is the yardstick of equal division. This is based on the objective of fairness and rejection of discrimination. The fourth principle is the rejection of minute retrospective investigations. That is because the law doesn't want you, as a divorcing party, to dwell into the past too much. Okay? They don't want you to keep looking at the past conducts of the other parties or the many, many details for accusation. It would waste too much time, energy, and costs, and you would be unhappy when you do it. Okay? In law, in finance, you simply want to arrive at a fair outcome in financial provision. So that's what Principle 4 is about. Okay? Should be easy to understand the 4 principles. With these principles, the court go through the 5 steps exercise in coming to a conclusion. In the judgment is paragraph 71 to 82. Step 1, identification of the assets. How do you do it? Simply, whatever that is under the name of the husband and whatever that is under the name of the wife would be taken into account, and then you add them together, then you have the full amount of family assets, prima facie. And we call that the matrimonial pot. You know the size, the scale of the whole of the matrimonial assets. Okay? In this process, you have to deduct your liabilities, such as mortgages and debts. But at the same time, the court would also consider the income, earning capacity, and other financial resources of the parties, as in Section 7, Subsection 1, Subsection A, in the list we went through earlier. Okay? So step 1 is look at how much you have, and step 2 is to look at how much you need. Assessing the party's financial needs. Needs can include regular expenses, housing needs, or other special needs such as medical, okay, or physical disability, that sort of thing. That would be under mainly Section 7, subsection 1, subsection B, on needs. But in assessing needs, the court would also look at the marital standard of living, the party's age, and any disability in subsection C, D, and E. And then, after you have the matrimonial pot, and then you have the needs, you compare the result between step 1 and step 2. If the matrimonial pot is big enough to cater for the party's needs, you go to step 3. And in step 3, you apply the sharing principle. So the starting point is 50-50. Each party has half. But when you compare step 1 and step 2, and you figure that the matrimonial pot is not sufficient to cater for the needs for both parties, then the exercise will stop there at step 2. You don't go on to step 3, there is no sharing, and then you just focus on needs. In step 4, if sharing is applicable, meaning that the matrimonial pot is big enough to cater for the needs for both parties, then you consider in step 4 whether there are any good reasons to depart from 50-50. Okay. The departing factors are also in the judgment. In paragraph 87 to 130, I think. So A, that's part of step 4, okay? So A, you look at the source of assets, which is a material factor. Assets independently acquired refers to assets which are acquired during the marriage by one spouse by way of gift or succession, or as a beneficiary under a trust, and also assets acquired before the marriage. These assets, by their nature, have nothing to do with the marriage. They are acquired from a source wholly external to the marriage. They are non-matrimonial in nature. Unilateral assets, broadly, they refer to assets sourced from the business or investment activities solely of one of the parties. The material factor of source of the assets would matter quite a lot in a short marriage. But the significance of the source of the assets would diminish over the years as the marriage continues. So if you have a long marriage, the source of assets does not really justify departure from 50-50. Conduct is another material factor which we will look at in greater details in next lecture. And then financial needs, especially special financial needs, such as special medical needs. Okay? Duration of marriage. So if a marriage is very short, then naturally it feels very unfair if you get to share half of the matrimonial assets, especially if the majority of the wealth is held by the other spouse. Okay? And then you also have contribution to the welfare of the family and compensation as material factors as well. And we will look at both of these in next lecture. Okay? These factors as you are aware, they're actually distilled from section 7, subsection 1. Okay. But these 6 factors in particular deserve further deliberation when considering whether there should be a departure from 50-50. Okay, and I'll go back to the previous slide. So after you've done all these things, if sharing is applicable, you go to departure in step 4, and then step 5 is just coming to a decision. For coming to a decision, you have to take a step back and assess everything, okay, as a whole, and consider the principles, whether that will be fair. The final assessment is fairness, actually. Okay, because basically, after you have done step 4, you already have the result. But why do we need to do step 5 at the very end? Because you have to assess fairness. Okay? These steps, it was said in the CFA decision, are guidance only. These steps are not binding. Okay? And if you follow the steps in step 4, for instance, even if there are reasons justifying the departure from equal division, you don't have to. You can still stick with 50-50, because ultimately in step 5, the court would have to assess the overall circumstances and ask if fairness has been achieved. Okay. This is very abstract. I appreciate if for your exam purpose, memorize all these things. Memorize this slide, and this slide. I think that will give you enough scores to pass and to basically to complete the heavy-weighted questions. In terms of applying, even if you know the steps, the principles, it's very abstract, you probably don't get it. So, in the ADR class, you should already have the factual scenarios already on your forum. I will use that factual scenario to demonstrate how this is applied in that specific set of facts, if you're interested. Okay? So, ultimately, in LKW and DD, it was found that both parties have earning capacity that would enable them to take care of themselves in going forward. The parties have equal contribution to the marriage. There is nothing to justify the departure in step 4. At trial, the wife had 1/3 at CA at the Court of Appeal. Our Court of Appeal says that there should be equal division between husband and wife. And the CFA, by elucidating the law, updating the law by adopting white and white, confirmed that there should be equal division in this case. Okay, so by equal division, the wife would have 2.3 million. At trial, she only got 1.55. Okay. Any question? That's the framework for financial division as between spouse. This is basically all you need for your exam. For a finance trial, the 3 slides. And section 7 factors. Okay. Any question, anything that you are not clear about? Okay. I'll repeat that again next time as a revision, and then we will dive deeper if you wish But for your exam purposes, these slides I think, are sufficient. Okay. So I will jump to children maintenance. Basically, in a divorce, the provision for children maintenance is stipulated in Section 5 of the MPPO. A Section 5 order is also an ancillary relief order, and children maintenance are dealt with together with spousal maintenance in the ancillary relief proceedings. Okay. And you remember when we talked about children, I told you that you have to distinguish the custody issue with children maintenance. They are dealt with in separate proceedings. You would deal with the custody and education first, and then you decide on the finance of the children at the same time as you determine on the financial arrangement for your spouse. Okay. So basically, if you read Section 5, subsection 1, it says that such orders of children maintenance can be made anytime during the matrimonial proceedings, before the decree of the divorce, at the conclusion of the proceedings, of course, after the trial, or even when the proceedings are dismissed. The relevant orders available for children maintenance is in Section 5, subsection 2. You have periodical payments in A, secured periodical payments in B, and also a lump sum order in C. Okay. And of course, you can Section 6 and Section 6A on property adjustments would also cover maintenance for children. Okay. But it's just that before they reach majority, the properties would have to be passed to a spouse to be held for the benefit of the children, because before they attain 18, they can't legally receive a flat, a landed property. The difference between maintenance for spouse and maintenance for children is that there is no clean break for the children, even though you can have a lump sum payment. For spouses, for adults, lump sum payment is inevitably a clean break arrangement. But for children, there is no such thing as clean break. Your responsibility to maintain the child, the family, continues. So usually, for children, the usual arrangement, it would be a monthly maintenance. You would have periodical payment in monthly payment for living and regular expenses like food, transport, that sort of thing. And you can have a lump sum. The lump sum would be for such as medical treatment, education, or buying a house. Okay, you can't have a lump sum clean break with your child. Limits, duration. Under MPPO, you can't make an order for maintenance of children if the children have reached majority. That's the starting point. There is an exception in Section 10, subsection 3, that the court has the power to extend that period if after the child has attained majority, he or she is still receiving education or training. So these days, usually parents would maintain the children until they finish their university, or sometimes even a master's degree. So usually the court would allow that. Okay, but it's very unusual if your child is already, say, 33, and you still have to maintain that child, even if it's for so-called training in trade. Okay, I think it's a bit, the court might not allow it. Okay. So for instance, for me to become a barrister, I have to do pupillage, my 1-year training. And at the time when I did my pupillage, it was unpaid. Traditionally, it's unpaid. So at that point of time, I was already, should I tell you? Because I have 2 university degrees and I have PCLR, and I did my pupillage. I was definitely passed. I have definitely passed my 25. I think I was exactly 25 when I did my pupillage. Okay, so in those circumstances, for me, then the court might allow continuous maintenance for this child. Okay. So for financial maintenance for the child, you can go beyond 18 years old. Okay. And remember, for custody, you can't. Okay, remember that difference? For custody, 18 years old is a strict line. After 18, you are out of the reach of the court or your parents. But after 18, you can still ask for money from your parents. They don't have custodial rights over you anymore. Okay, and in making a children maintenance for children order, the relevant factors are in section 7, subsection 2. For spouse, it's subsection 1. For children, it's subsection 2. They are very similar to section 7, subsection 1, but subsection 2 is more oriented towards the needs of a child. Okay, I won't read them out loud. You can have you have the slide for your reference. In practice, if you take up any judgment on ancillary relief, the considering factors for children would be looked at together with the factors for spousal maintenance. So you won't usually see a separate discussion on section 7, subsection 2. In a judgment, the court will usually just quote subsection 1 and then goes on to discuss any aspects that affect the spouse and the children. Okay, so you don't have to rehearse both lists for the judgment. It's basically duplicated, largely overlapping. There is also subsection 3. So basically, in a situation where the father is not the biological father of the child, but has nevertheless treated the child as a child of the family. So in deciding whether this husband should be ordered to make financial provision for the child, the court shall look at the whole circumstances of the case. So apart from section 7, subsection 2, the court would also consider whether that husband had assumed any responsibility for the child's maintenance, and if so, to what extent, and the basis upon which the party assumed that responsibility, and the length of time for which the party discharged the responsibility. Okay, and also the court looks at whether the party maintained the child, knowing that the child is not his own. And also the court consider the liability of any other party to maintain the child. So for instance, the biological father. So these considerations are also for achieving fairness. In a case where there is an order made against party, and the child, the family, is not his child biologically. Okay? I have this one last slide for the situation that is not divorce. The law on children maintenance for illegitimate children is different. Because when you have an illegitimate child, as between the father and the mother, they're not married, and hence MPPO is not applicable. So instead, you have to turn to the GMO, and that is in section 10, subsection 2. Okay. I've highlighted the important bits for you. You can have a lump sum. In A, you can have a lump sum payment. But note that it is only for the immediate and non-recurring needs of the minor, or for the purpose of enabling any liabilities or expenses reasonably incurred in maintaining the minor before the making of the order. It's for immediate non-recurring needs. That means that it cannot be ordered, a lump sum cannot be ordered for the purpose of housing, because housing is recurring. Okay, you need a residence every day. It's not it's not things that you only have to do once. Okay. In B, you can have periodical payment for children maintenance. And also, C is secured periodical payment, D is transfer of property, E is settlement of property. But all these things are subject to reasonableness. Whereas in a divorce situation under MPPO, there is no such limit. So theoretically, you can see that our legislation has discriminated illegitimate children. By these wording of reasonableness, you would expect that in comparison, children maintenance for illegitimate children would be less than children who were born in wedlock, because of reasonableness. Okay. For this reason, the certain provisions in the GMO has been criticized to be discriminatory and is not fair, and this would have to be addressed by a change in our legislation, and perhaps by a consolidation of all the children law that I told you about in children lectures. Okay, so just remember, I'm not sure if this is in your manual. If not, then it's not examinable. I'm not sure, you have to check. But this is just so you know about the difference in law when you have a child who is not born, who is born out of wedlock. Okay, it's not the same. It's more limited. Okay. So today you have the basic framework for ancillary relief order. Okay? You have the orders for the spouse, you have section 7 factors, you have LKWNDD, and then you have section 5, MPPO, which is for children maintenance in divorce, and then certain rules in section 7. Okay. Any questions? Anything that is not very clear? It's easy to memorize LKWNDD, but not easy to understand. And if you have no questions, that will be it. Okay, I'll stay here for maybe another 15 to 20 minutes. The next class is on next Wednesday because next Monday is a public holiday. So I hope you have a nice Christmas. Okay, and